It tells employers that the Department of Labor, that's one of its initiatives to make sure that employees and workers are properly classified and not misclassified as independent contractors. My name is Lori Peterson. I am a board member and attorney at the law firm of Lindner and Marzak. We are a boutique labor and employment law firm in Milwaukee, Wisconsin. For a number of years, the Obama administration and its Department of Labor have talked about the issues involving wages and classification for employees, and particularly the payment of overtime. So the Department of Labor issued proposed regulations which raised the salary exemption for overtime exempt individuals from $455 to a 2016 adjusted rate of $970 weekly. The salary threshold hasn't been increased for a decade or more. Employers need to look at the employees in their workforce who are categorized as exempt employees, look at the current salary level of those employees, and make a determination whether or not the employer is going to be able to increase the salary to the level expected by the regulations, or perhaps make a determination to convert those individuals to hourly paid employees with overtime. Under the proposed rules, the Department of Labor will allow an employer to take credit up to 10% of the weekly salary for the payment of non-discretionary bonuses and incentive pay. The important point there is that they have to be non-discretionary payments. The EEOC recently issued a memorandum, which is a guidance document. It's not a change in the law or the regulations. But it's a guidance document to employers to explain to them how the agency will make a determination whether or not a worker in their workforce is going to be classified as an employee or an independent contractor. The significance of the memorandum is not that it changes the law, but it tells employers that the Department of Labor, that's one of its initiatives to make sure that employees and workers are properly classified and not misclassified as independent contractors. The reason for that is if an employee is misclassified as an independent contractor, the employer doesn't contribute to unemployment compensation, does not contribute to workers' compensation. The individual employee, even if they're eligible for it, would not receive overtime pay. So it's important for the Department of Labor to make sure that employers are classifying employees appropriately.